Hello and welcome to episode 5 of Keating Chambers Adjudication webinar series. This webinar is going to be all about resisting enforcement on the basis or utilising Part 8 proceedings. My name is Isobel Kamber and I'm a junior tenant here in Chambers, and I'm joined by two other junior tenants, Ben Graff and Tom Walker. And I will begin today's webinar. So, the classic mantra about adjudications is pay now, argue later, and that comes from Carillion Construction and Devonport Royal Dockyard Limited, and that was a 2005 Court of Appeal decision in which Lord Justice Chadwick said that the task of the adjudicator is to find an interim solution that meets the needs of the case. The need to have the right answer has been subordinated to the need to have an answer quickly. There are, however, 4 exceptions to the pay now, argue later rule, and those are where the adjudicator is acting or has acted in excess of their jurisdiction, where the adjudicator is in breach of natural justice, where there is an admitted error or no adjudication clause, or where there is a preemptive strike utilising Part 8 proceedings. And that's what we're going to be discussing today. So what might be a losing party's thought process? Section 108, subparagraph 3 of the Housing Grants Construction and Regeneration Act 1998, the scheme, provides that the contract shall provide in writing that the decision of the adjudicator is binding until the dispute is finally determined by legal proceedings, by arbitration or by agreement. The TCC guide provides at paragraph 9.2.8 that the court will ordinarily list an enforcement hearing within about 6 to 8 weeks of an application to enforce an adjudicator's decision. And Civil Procedure Rule 8.1 subparagraph 2 provides that a claimant may use the Part 8 procedure where they seek the court's decision on a question which is unlikely to involve a substantial dispute of fact. So you can see specifically from the TCC guide that there is a need to act quickly if you are going to be resisting enforcement utilising Part 8 proceedings, but that the Part 8 procedure is possible to resist an adjudication enforcement. However, what are the circumstances in which you can resist an adjudicator's decision on the basis or utilising Part 8 proceedings? That's what I will be going through today. So the starting point is Hutton Construction Ltd and Wilson Properties London Limited, and that's a 2017 High Court TCC decision. And the facts of that case were that Hutton was the contractor, Wilson was the employer, and a dispute arose over unpaid sums, and Hutton referred the matter to adjudication. The adjudicator awarded a sum in Hutton's favour. Wilson failed to pay, so Hutton applied to the court to enforce the adjudicator's decision. The central issue was whether a valid pay less notice had been served. This was a question of law and a question of construction of the notice, and it was not a question of the underlying factual matters. There was fundamentally no substantial dispute of fact. Both parties agreed on the content and timing of the payless notice, or alleged payless notice, I should say, and the court only needed to assess whether the document issued by Wilson qualified as a payless notice, which was suitable for Part 8 determination. Hutton sought to enforce the adjudicator's award, and Wilson sought to resist on the grounds that a valid payless notice had been served. The court used Part 8 to clarify whether the adjudicator had jurisdiction, which turned on the validity of the notice, and the result was that the court enforced the adjudicator's decision in favour of Hutton. So what was the court's reasoning for that? Well, as we've already highlighted, the general rule is that an unsuccessful party to adjudication cannot resist adjudication enforcement on the basis that the adjudicator got it wrong. However, as you will have gauged from the decision in Hutton and Wilson, the court found that there was one narrow exception to this, and that was identified by Mr. Justice Coulson, as he then was. And the exception was identified at paragraph 17 of the judgment, and that is, where there is a dispute between the parties as to whether or not the defendant is entitled to resist summary judgment on the basis of its Part 8 claim, the defendant must be able to demonstrate that, firstly, there is a short and self-contained issue which arose in the adjudication and which the defendant continues to contest. Secondly, that the issue requires no oral evidence or any other elaboration beyond that which is capable of being provided during the interlocutory hearing set aside for the enforcement. And thirdly, that the issue is one which on a summary judgment application, it would be unconscionable for the court to ignore. And that's also reflected in paragraph 9.4.5 of the TCC guide. However, this does not mean that the issue cannot be nuanced or that the answer must be obvious, and that comes from Elements Europe Limited and FK Building Limited, a 2023 High Court decision at paragraph 33. But you can see that the circumstances in which you might be able to use a Part 8 procedure to resist enforcement is narrow and it is self-contained. Coulson continued in his judgment by saying, "It is axiomatic that such an issue could still be considered by the court on enforcement if the consequences of the issue raised by the defendant were clear-cut. In Caledonian Modular, it was agreed that if the document was not a payment notice, and it plainly was not, then the claimant's case failed. If the effect of the issue that the defendant wishes to raise is disputed, it will be most unlikely for the court to take it into account on enforcement. Any arguable interleafing of issues would most certainly be fatal to a suggestion by the defendant that their challenge falls within this limited exception." So as you can see, Mr. Justice Coulson, as he then was, clearly narrows the issue, the circumstances in which Part 8 might be used. Following on from Hutton and Wilson, there has been obviously a variety of case law on the subject and discussing the use of Part 8 claims to resist enforcement. One such case is Merit Holdings Limited and Michael J. Lonsdale Limited, and that was a 2017 High Court decision. And in that case, Merit was a subcontractor and Lonsdale was the main contractor, and a dispute arose over interim payment applications and the valuation of works. Lonsdale issued a pay less notice, but Merit argued it was invalid, and Lonsdale sought declaratory relief under Civil Procedure Rule Part 8, asking the court to decide whether a specific sum had become due based on an interim application and whether the pay less notice was valid. In the judgment, Mr. Alexander Nissen, KC, sitting as a deputy judge of the High Court, talked about the appropriateness of Part 8, and he said at paragraph 22 that the experience of this court shows that there is a real risk of the Part 8 procedure being used too liberally and inappropriately, with the risks both of prejudice to one or other of the parties in the presentation of their case, and of the court being asked to reach ill-formulated and ill-informed decisions. He went on to say, to talk about clarity in that, well, actually prior to that, he talked about clarity. And he said at paragraph 21, "It seems to me to be implied in the rules that the question should be framed with some degree of precision and or be capable of a precise answer." That's something that obviously is perhaps self-evident, but it is good for the court to make such things clear. And on that note, I will hand over to Tom, who is going to be talking about arguably the most important decision on Part 8 proceedings being used to resist enforcement, and that is AVB and JB Hopkins.
Thanks very much, Isobel. So the Hutton line of cases was recently considered by the Court of Appeal in the case of AVB and JB Hopkins Ltd. The Court of Appeal provided important guidance on the use of Part 8 proceedings to resist adjudication enforcement. I think it's safe to say that this judgment is essential reading in this area. So turning first to the facts, the appellant, A&V Building Solutions Limited, commenced a smash and grab adjudication on 17th November 2021 in respect of its payment application number 14. On the 2nd of December 2021, whilst the adjudication was still ongoing, the respondent, JB Hopkins Limited, issued Part 8 proceedings seeking declarations as to the invalidity of AVB's payment application. In summary, it argued that on a proper construction of the parties' contract, there was no entitlement to payment in respect to the application as it had been made late. On 19th of January 2022, the adjudicator issued his decision. he found that a total of £138,010 was due to AVB. On 24th March 2022, AVB commenced proceedings seeking to enforce the adjudicator's decision. On the 12th of April 2022, JBH's Part 8 claim was heard by Mr. Justice Eyre. He held, amongst other things, that the payment application was invalid. Either because of that decision or because of a subsequent adjudication that we will come on to, AVB abandoned the application to enforce the first adjudicator's decision. AVB was granted permission to appeal Mr. Justice Eyre's decision on 3 grounds. Ground 1 was whether the Part 8 proceedings were an abuse of process. Ground 3, whether the judge had been right to conclude that the payment application had been made late and was of no effect. And finally, Ground 4, whether the judge had been right to reject AVB's arguments on variation, waiver, and estoppel. In the interim period before the handing down of the Court of Appeal's judgment, the parties went on to fight a second adjudication concerning the value of AVB's final account. That second decision found that AVB had in fact been overpaid and required AVB to pay back to JBH the sum of £82,956. AVB failed to do so, and that decision was in fact subsequently enforced. The point to note is that the effect of this decision was that no further money was in fact owed to AVB, and the significance of that will become clear in a moment. That brings us to the decision of the Court of Appeal in this case. As a preliminary point, it should be noted that the Court of Appeal's judgment contains strong criticism of the parties' approach to adjudication enforcement. In particular, as the second adjudication decision had resulted in no sums being due to AVB, the appeal was academic from a financial point of view. Lord Justice Coulson expressly lamented the costs that had been incurred to achieve what was in effect a stalemate between the parties. The parties' failure to follow the guiding principle of construction adjudication, namely pay now, argue later, that Isobel has highlighted to us, was also heavily criticised and influenced the content of Lord Justice Coulson's judgment. That can be seen from the quoted paragraph 2 on the slide. Accordingly, this judgment serves as a salutary reminder to litigants to consider carefully the approach they take to adjudication enforcement. A failure to do so may well prompt a sense of humour failure from the court. Turning then to the grounds of appeal and the court's consideration of them. As to ground 1, where there was an abuse of process, Lord Justice Coulson provided a helpful summary of the relevant principles and guidance at paragraphs 34 to 40 of his judgment. The following points are worth noting. At paragraph 34, he states that the starting point for any consideration of the Part 8 proceedings in this case, which found no mention in the judgment below, is the guiding principle behind construction adjudication: pay now, argue later. At paragraph 36, he highlighted, it has long been the position that court proceedings are open to the parties, even in an ongoing adjudication. However, at paragraph 37, he noted that TCC had become increasingly wary of allowing Part 8 proceedings to be used to circumvent or undermine an ongoing adjudication. At 38, he confirmed the proper approach to parallel proceedings was that the judge should usually give judgment on the claim based on the adjudicator's decision, and then, to the extent possible, endeavour to sort out the Part 8 proceedings. As set out in Hutton, the Part 8 claim should be dealt with after the enforcement, unless the point raised was straightforward and self-contained, and the parties were agreed that it could be dealt with at the enforcement application without adding to the time estimate. At paragraph 39, he emphasised that warnings have continued to be given as to the over-liberal and inappropriate use of Part 8 in adjudication cases. In the same vein, he cited with approval the wording of the TCC guide at paragraphs 9.4.4 to 9.4.5 at paragraph 40 of his judgment. Those paragraphs, amongst other things, adopt the test in Hutton that Isobel has taken us through already. Applying those principles to the present case, Lord Justice Coulson dismissed ground 1, the Part 8 proceedings were not an abuse of process. At paragraph 41, he set out the crux of this. It is clear to me that the judge was right not to accede to AVB's application to strike out the Part 8 proceedings as an abuse of process. That application, which was made very late in the day on 7th April 2022, had no basis in law. The authorities to which I referred make it crystal clear that court proceedings remain open to parties to construction adjudication. There is nothing in the 1996 Act to suggest otherwise. Whilst I regret JBH's costly decision to set up two competing sets of proceedings, with the Part 8 claim relevant only if JBH lost the first adjudication, it was an approach that, as a matter of law, was open to them. At paragraph 43, Lord Justice Coulson went on to set out what should have happened at the first instance hearing. He stated as follows: the position was that JBH were in breach of contract because they had not paid the first adjudicator's decision, and that in light of the pay now, argue later mantra, should have been the first order of business. Having determined the enforcement position, the secondary question for the judge was whether AVB should lose their entitlement to enforce the decision in the first adjudication on the basis of JBH's Part 8 claim. For completeness, it should be noted that Lord Justice Coulson did accept at paragraph 44 that some elements of JBH's claims raised issues of pure construction which may be suitable for Part 8 determination, even in the context of an adjudication enforcement. Turning finally to grounds 3 and 4, the appeal was allowed on ground 3. However, as stated previously, this was academic by the time of the judgment. Lord Justice Coulson stated that, although I consider that AVB were entitled to enforce the first adjudicator's decision back in April 2022, that entitlement has long been overtaken by events, and in particular by the result of the second final account adjudication. In the circumstances, it was unnecessary to deal with ground 4, but the court did make some obiter findings in relation to the arguments on variation waiver and estoppel that can be found at paragraph 65 to 72 of Lord Justice Coulson's judgment. So that is the case of AVB. As I said, it is an important case and essential reading for people looking at this area. And with that in mind, I will turn over to Ben Graff.
Thank you, Tom. I'm now going to discuss how the concepts that have been outlined by Isobel and Tom have been applied in recent first instance decisions. In particular, I'm going to consider the cases of Breakshaw and Redkey concepts, T. Clark and Bell Build, and ISG and FK. Starting off then with Breakshaw. This case relates to an adjudicator's decision that Redkey Concepts, the contractor, was liable to pay Breakshaw, the employer, £285,000 in liquidated damages for delay. Breakshaw applied for summary judgment to enforce the decision. Redkey resisted this application, although did not raise any jurisdictional or natural justice objections. It said that the decision was obviously wrong and sought a determination of the dispute by way of Part 8. In particular, it sought declarations that it was prevented from completing the works and was entitled to suspend its works. The court held that Part 8 was not appropriate for this dispute. It said that the issues between the parties involved consideration of whether the contractor was reasonable to suspend its works and the causes of the delay to the works. It said that these were significant questions of fact which could not possibly be disposed of in a Part 8 claim. The court then concluded at paragraph 25 with the quote that you can see on the screen. It said, overall, as I say, there is no clear-cut issue from which it can be seen the adjudicator was obviously wrong to decide that liquidated damages were due for that period. On the contrary, there are interleafing issues, including issues of fact and evaluation, which cannot be disposed of with the enforcement proceedings on this occasion, and which therefore mean Part 8 certainly cannot be used to defeat the summary judgment application. Indeed, they mean that Part 8 is not appropriate at all. The court added that the wrong course had been taken for tactical advantage and had awarded the claimants its costs on an indemnity basis. The next case, as I said, is T. Clark Contracting and Bellbuild Limited. Bellbuild was awarded £2 million in a smash and grab adjudication, and T. Clark Contracting sought declaratory relief that it had issued a valid pay less notice, and as such, that the adjudicated decision was wrong and no payment was due. The question of whether the pay less notice was validly issued under the contract was dependent on whether the parties had, by agreement, varied the procedure for the assessment of interim payments. The claim was pleaded in part, as you can see on the screen, that the adjudicator's decision was wrong in law. The court held that that pleading was misconceived. As you can see there, it said that the claim is pleaded on the flawed assumption that the court will review or hear an appeal from the adjudicator's decision. That is not the function of the court. Rather, it must finally determine the party's rights for itself. The court held that Part 8 was also not appropriate for this dispute. It said that whilst a dispute concerning the proper construction of a written contract is the paradigm example of a case that might be suitable for the Part 8 procedure, that is not the case where there is a dispute as to whether the terms of the contract have been varied, which were the facts of this case. It said any issues as to the existence of and terms of any contractual variation must be determined by witness evidence. And as a result, it concluded in paragraphs 20 and 21, which are on screen, as follows. In my judgment, the proposed use of the Part 8 procedure in this case is laden with risk that the court might reach ill-formulated and ill-informed decisions that will not finally dispose of the disputes between the parties. Further, I am not satisfied that T. Clark has identified one or more precise legal questions that can be properly tried upon clearly identified agreed facts and which will be determinative of the current dispute between the parties. Accordingly, I conclude that the use of the Part 8 procedure was plainly inappropriate and that this case must proceed under Part 7. So again, the court is, in applying the Hutton and Wilson criteria, to deciding that Part 8 is inappropriate for these two disputes because they involve questions of fact, which are not self-contained and cannot be determined without evidence, and because the consequence of their determination is not clear in relation to the adjudicator's decision. It's not clear-cut as is required. Okay. Now, this is the third and final case that I'll be considering. And in this case, it was held that Part 8 was appropriate and the claim was successful. The facts are as stated on screen, which were that FK was ordered to pay £370,000 to ISG in relation to defects in the construction of a distribution centre. ISG commenced Part 7 proceedings to enforce that decision, and FK then commenced Part 8 proceedings, seeking declarations that the adjudicator had made an error in his assessment of damages to ISG. So, in essence, this was not the sort of the usual grounds for resisting enforcement, where either the defendant raises natural justice or jurisdictional objections. It was also not saying that there was a succinct point of law that showed that the adjudicator's decision was wrong. Rather, this was a slightly novel claim, which was just that on the adjudicator's own according to the adjudicator's own reasons, the sum of £370,000 was wrong. I.e., if he'd have carried out the calculation that he deemed to be the relevant calculation correctly, then he would have arrived at a different figure. That was essentially the claim. So FK commenced Part 8 proceedings seeking declarations that the adjudicator had made an error in his assessment of damages. In particular, it said that in determining the loss that ISG had suffered from FK's failure to complete the works, the adjudicator had given credit to ISG for the sum that was payable to FK for the proportion of the works that it had completed, which was £330,000, when ISG had not in fact paid FK for the full value of its works. The figure that the adjudicator should have used instead of that £330,000 was the sum that FK had actually been paid, which was the much smaller figure of £54,000. The court accepted that that was an incontrovertible error on the part of the adjudicator, and that it had resulted in the award being £250,000 higher than it ought to have been. The question for the court was whether it was entitled to correct this error when considering ISG's application for summary judgment or when considering FK's Part 8 claim. The court held that it was. It said that the error fell within, in this passage as you can see on screen, it said the error fell within the limited exceptions outlined in Hutton and Wilson, which Isobel went through previously. They are then set out again there, as you can see at A, B and C. In short, it's required that it is a short self-contained issue that requires no oral or other evidence, and that it will be unconscionable for the court to ignore. The court found that those factors were present in this case. It said, I'm satisfied that all three of those factors are present. The mistake made by the adjudicator is a short and self-contained issue, which arose in the adjudication and which the defendant continues to contest. That issue requires no oral evidence or any elaboration beyond that which is capable of being provided during this hearing. The issue is one which it would be unconscionable for the court to ignore on this summary judgment application. If the court were to do so, ISG would recover a windfall sum approaching some £250,000. The court also found that this was a clear-cut issue that had clear consequences, and that's the second passage at paragraph 38. It is entirely clear on the figures found by the adjudicator by what amount his decision falls to be reduced. There is no arguable interleafing of issues of the kind that Coulson J considered would almost certainly be fatal to any suggestion by the defendant that their challenge falls within this limited exception. Finally, the court rejected ISG's submission that the court was not permitted to correct an error of law that had been committed by the adjudicator. It said this: I do not consider that the defendant's characterization of the error as one of law precludes it from raising this point by way of defence. As I pointed out to Mr. Brannigan, one of the examples offered by Mr. Justice Coulson of a situation where a defendant might legitimately challenge an adjudicator's decision is where his construction of a contract clause is beyond any rational justification. An issue of construction is, of course, an issue of law, and therefore it cannot be the case that merely because an issue is one of law, it is incapable of being raised by way of defence to the summary enforcement of an adjudicator's decision. Now, what the judge does not say is that this was a slightly unusual error of law, in that there was not a discrete issue that the court could finally determine, i.e. the court was not being asked to determine the actual damages that were due to ISG, because that would have required the court to determine whether or not there were defects and the remedial works that would be required to rectify those defects, if so, which of course would involve a substantial dispute of fact. The question in this case, as I said before, was the unique one of in accordance with the adjudicator's own reasoning, what number should have been granted by way of damages. And it might seem that what the judge is saying here is slightly different from what the court said in T. Clark, which is that the parties should not plead that the adjudicator's decision is wrong in law, as the function of the court is not to review the decision of the adjudicator. Perhaps the way that these cases can be reconciled is that the court will not generally review or correct adjudicators' decisions, save in exceptional circumstances, where there is a clear error that is beyond all rational justification, as there was in ISG and FK. That is obviously a very high bar that, as we have seen, will not be met in the majority of cases. That is all from us. Thank you very much for listening.